Topic that's been invoked multiple times already today. We've heard people from the very first panel through to the last one talk about questions of rule of law and whether the rule of law is foundational and part of democracy. So that's what we're going to dig into in this panel. The title of the panel is The Legal System, Judges and Prosecutors. And we're going to be looking generally at how and under what conditions executives encroach on the judiciary and the legal system, and how courts and judicial operators can contain that process of encroachment. We have four excellent panelists. We have Diane Desierto, who's a professor of law and global affairs at the University of Notre Dame. She's also the faculty director for the LLM in International Human Rights Law and the global director of Notre Dame Law School's Global Human Rights Clinic. We have next to her Benjamín García Holgado, a graduate of the University of Notre Dame and currently assistant professor of political science and international relations at the University of Delaware. Next to him is Diane Kapiszewski, Provost Distinguished Associate Professor of Government and the Director of the Center for Latin American Studies at Georgetown University. And at the end, Julio Ríos-Figueroa, Associate Professor of Law at ITAM, the Instituto Tecnológico Autónomo de México. All of them have done extensive work on law, rights, rule of law, and have thought a lot about how law and democracy interact and support each other. The specific questions we're going to be asking them to address are how and under what conditions do executives encroach on the judiciary and the legal system? How can courts and judicial operators contain that process of encroachment? And what are key examples of success or mistakes to be avoided? Each will speak for about 12 minutes, except Benjamín and Diana, who will combine their time. Why don't we start with Diane?
Yes, thank you. Good afternoon. First and foremost, thank you to the Kellogg Institute and the Keough School of Global Affairs for hosting what is an extremely critical discussion, especially in these times we face, not just here, but also around the world. It's heartening to me to hear several things that I've been working on for the last 20-odd years of my life. A colleague mentioned the word hyper-presidential. In 2011, I wrote the article Hyper-Presidentialism in the Berkeley Journal of International Law that warned that there can be separation of powers without checks and balances, how it's so easy for presidents to deploy executive power constitutionally in a way that would erode judicial independence, in a way that can undermine very easily judicial authority. And this is a paradox of constitutionalism, because in the first place, the judiciary is the weakest animal in any constitutional structure. Lawyers are also distinct animals in and of themselves. I know Shakespeare said, let's kill all the lawyers, but let's not take that literally. Lawyers take an oath, and I stand here as a lawyer from the Philippines for almost a quarter of a century. I've been a lawyer for the Philippines, and I took that oath. Unlike the US Constitution that doesn't mention the word democracy, the Philippine Constitution requires us to support democracy, human rights, and the rule of law. So this is something I take seriously, but also something that I'm cognizant of, where we have four distinct constituencies we serve as lawyers. It's not just the client. First and foremost, we support Constitution and the rule of law. Second, we are officers of the court. Whether we're in government, in academia, whether in private spaces or civil society, we are always officers of the court, there to promote rule of law in any system. Third, we have duties to our profession, precisely because, unlike most marriages, your oath to support the Constitution, the lawyer's oath, is an oath you carry to the grave. This is precisely why, in the era where democracy is challenged and executive power, as we've heard this morning, can overreach, this is the time when lawyers are trained to do what they are supposed to do: defend Constitution, support the rule of law, support the courts, support our profession, support clients. And yet, as I've said, the judiciary is the weakest animal. It can so easily be dismantled by the executive branch or by Congress by simply gutting it of any budget. Appointments processes can be held up. Judicial seats can be vacant for a really long time. And if they're vacant, cases can't be heard. It's also entirely possible to threaten judges with impeachment or actually impeach them, as was done in the Philippines at the height of Duterte's regime when the Chief Justice of the Supreme Court of the Philippines was impeached forcibly by the House of Representatives and the Senate, and by a decision of the Supreme Court of the Philippines. It's also all too easy for lawyers when we are asked to stand and make representations before courts to represent someone else. It's all too easy for lawyers to be targeted. I lived that. In my third day at Notre Dame, when I started right around the same time as our Kellogg Institute director, Anibal, in my third day at Notre Dame, my law firm was attacked by Duterte. The lawyers were abducted, and they were there to monitor a routine search for one of our clients. That was the very first time in the history of the Philippines that a president had openly gone up against a law firm. And I know precisely why they did that. It was because the month before, I am one of 2 counsels at the time that were admitted to the International Criminal Court, and I had filed the specific complaint with the witnesses, with the evidence, on behalf of the then chairperson of the Philippine Constitutional Commission on Human Rights. The message given to us back then was, play ball with the administration. Don't do this. You don't have to be the one to do it, was the one message I kept getting from many colleagues in the profession who said, Diane, just keep your head in the sand. Except the difficult thing with that is we all have to live with our consciences. And we all have to live with our oaths. So for the last 7 years I've been here at Notre Dame doing the work that I've been asked to do. For the last 7 years, this is partly why I also appreciate the opportunity to give this case study of hope, in a way. For the last 7 years, in a big, broad, deep, and quiet coalition of lawyers, of civil society actors, of the Catholic Church, who also helped shelter our witnesses, for the last 7 years, we worked hard to bring that case from complaint to preliminary examination to judicial investigation, and finally to the arrest warrant that was executed just several months ago. In September, the former president, soon to be the mayor of Davao again, because I hear he's about to be elected again, is going to stand trial. And that for us as lawyers, thank you, but thank my colleagues. Frankly, my colleagues on the ground suffered infinitely more than I did. That happened at a price. At the time of the Duterte administration, it was interesting, Scott and Thomas earlier were talking about when's the line that you draw. To me, the line's pretty simple. When they start shooting at lawyers, when they start shooting at judges, the line's been crossed. That's what happened during the Duterte administration. Nearly 100 lawyers and judges were shot in court. And there was impunity, there was no law enforcement that was brought to assist. My own law firm, my own family's law firm, kept getting bombs. It was regularly sent in the mail. I was told not to come home, also why I stayed a lot at the Keough School. Provided a whole lot of shelter. But that was part of the risks that we took as counsels because our oath is to Constitution, the rule of law, human rights, to democracy, as it is specifically indicated in the Philippine Constitution. Which is why when I talk about what can executives do to encroach in the judiciary, my answer is everything. They can do everything even within the parameters of the Constitution. Don't give you a budget, hold up your appointments, delay executing your writs. Judges speak, and judges have authority only because they are vested by the Constitution with the authority to declare what the law is. And when judges are undermined, when judges are attacked, when judges are arrested, there is a clear signal that is sent to the judiciary, to the legal profession, that if you don't play ball, there are consequences. So flipping to the side of what could we have done better, I wish we had the technology advances back then. It would have made a whole lot of preparing for our evidence before the International Criminal Court a whole lot faster. We can build coalitions, which is what lawyers are supposed to do. We are here as representatives of our clients, first and foremost. But we need the clients. We need the clients to decide that this is what they want to pursue. When everybody wants to put their head in the sand, it's difficult for lawyers to just say, we'll do it. Because in the first instance, lawyers have fealty to the Constitution, to the rule of law, to the courts, as well as to our clients and to the profession. So we need clients who care and clients who do want to stand up. The second thing that we also need, something so basic, I had to tell my student about it earlier, we need more lawyers. This is a difficult profession. It's not for the faint of heart. Requires a lot of tenacity, a lot of training, a lot of humility, and a lot of, and sometimes, sense of humor. In 7 dark years of fielding a lot of interesting messages from a very powerful administration for the last 7 years. For the last 7 years, I had to pretend that I was a college student every time I entered through one of the ports of the Philippines. But that's a risk that we take, and it would be easier if there were many of us. It's also one thing that we could also do at this time, educate. We get so many people on social media these days. I'm sure everybody over the weekend heard the phrase habeas corpus. But we need to educate more and more of our citizenry to be empowered to value the same rights that were conferred on them by the Constitution. We talked earlier about why is it that people won't care. Frankly, and maybe in my experience in the Philippines, until you're deprived of the right, until you've known the right to speak, the right to peaceably assemble, the right to express oneself, the right to hold one's beliefs without consequences, until you've known what that's like and you've seen yourself day in, day out be deprived of it, no one's really going to value it. In the Philippines in 1986, while I was, in my own lifetime, the dictatorship fell peacefully with zero violence. I mean, we talked about nonviolent protests. That was a protest in rosary praying. And yet that brought out a dictator and that saw a dictator fall. But the ensuing years also taught us it's not enough to have an EDSA revolution moment. It's not enough to have the one lawyer who says something. You need sustained engagement by the citizenry that knows what their rights are, especially in these times. I've done far too many know your rights issues at this time. That knows what their rights are, that are certainly hell-bent on making sure they don't bury their heads in the sand. But we also need more, not just students, but more people to do what we teach at the Human Rights Program at the law school. Look at the human, first and foremost, before you practice the rights. A lot of us see a lot of people, and one of the things we like to teach at the program is don't try to vindicate anybody's rights until you actually know the human. And that requires sustained engagement. That requires commitment, not just being passionate about human rights, but being committed to do it day in, day out, even when it's not glamorous, and frankly, even when it's exhausting. The more of us that can see the human, first and foremost, will ensure that you put us out of jobs. And frankly, I'd love nothing better than to retire as a gardener. On that note, I'm going to stop. Thank you.
Diana, me paro para ese light sword.
Thank you, Diane. Diana? Yes.
Great, thank you. Good afternoon, everybody, and thank you very much for including me in today's conference. This has been wonderful, and I'm learning a lot. Courts hold the potential to play a significant role in relation to democratic backsliding around the world. In some countries, courts have facilitated autocratization. So in Venezuela, for instance, after being co-opted by Hugo Chavez, the Venezuelan Supreme Court validated the president's autocratic moves. In other countries, courts have used judicial review to slow democratic decline. So in Colombia, the Supreme Court resisted President Álvaro Uribe's interference with its investigations. And in some countries, courts have played different roles over time. Courts playing either role can have major consequences both for democracy and for the rule of law. So our presentation today focuses on judicial attempts to slow democratic decline, what we and others have called judicial resistance. So courts trying to slow democratic decline can be risky for all the reasons Diane Desierto just pointed out, given courts' vulnerability to political retaliation and their overall lack of power. It's important then for us to study and understand when and where and why and how they nonetheless play that critical role of resisting autocratization. So a necessary prerequisite for answering these questions is being clear about what we mean by judicial resistance. That is, clearly conceptualizing judicial resistance. Conceptualization is the bedrock of any research program, and the emerging research program on democratic backsliding is young enough that we still have an opportunity to build solid conceptual foundations. And Benjamín and I hope to contribute to that with this paper and with this presentation. So the presentation today proceeds as follows. First, we'll talk a little bit about how other scholars have conceptualized judicial resistance. Then we'll offer and develop a conceptualization of our own. And we'll begin with considering judicial resistance in the abstract, and then we'll focus in on the special case of resistance to democratic backsliding. And then we'll close with some preliminary ideas on the effectiveness of judicial resistance.
So as Diana said, one of the motivations of this paper is the fact that scholars and also practitioners have been increasingly using the term judicial resistance, but the usage of this term has three important limitations in our view. The first one is that there are many cases where the term judicial resistance is not even defined. And when it's defined, it's just defined in a single sentence without any further clarification on that. Secondly, all the definitions that we have found of this term are extremely narrow. They are extremely tied to the interest of the scholar studying this term. And also, as a consequence, they are contradictory. Like the scholars are talking past each other because they are using the same label, the same term to refer to different things. And lastly, none of the scholars and practitioners that are increasingly using these terms repeatedly have used the long and well-established literature we have in social science on how to best conceptualize. So a goal of our paper, of our research, is to contribute to this literature addressing these three issues.
That's the last switch that we'll do. So, as Benja says, the conceptual framework that we're developing accommodates multiple types of pushback by courts. So we define judicial resistance in the abstract as an action by a judge who actively and intentionally rejects an action taken by another actor concerning specific issues under contestation. So we're going to sort of take that apart bit by bit. So we understand judicial resistance to be one type of judicial reaction, so a broader overarching concept that also includes judicial evasion, approval, advocacy of another action's actors. So our definition also entails an understanding of resistance that it can vary in effectiveness. It may work or it may not, as well as in what causes it and what its consequences are. So our definition of judicial resistance has 6 attributes. The first attribute concerns how the resistance is undertaken, the action or the actions that are taken by one or more judges. So courts can resist in many ways, directly or indirectly, through rulings or other actions, independently or in collaboration with people who aren't judges. So you see here one example. Judges in their robes singing the national anthem during the March of 1,000 Robes, in which Polish judges protested against changes to the Polish judicial system. The second attribute concerns who resists. One or more judges, first instance judges, apex court judges. For instance, here we see Polish District Court Judge Igor Tuleya, who in 2017 ruled against the incumbent party in a case concerning the legality of a parliamentary vote on the budget, underscoring the public's right to be informed about the proceedings. Also, our definition entails intentionality. We understand judicial resistance to be the product of a deliberate decision to oppose or reject something or someone. So here's an example from Israel in which the president of the Supreme Court denounced government plans for legal reform given the reform's potential effects on the power of the Knesset. The fourth attribute concerns what is being resisted. Judicial resistance is directed against something undertaken or to be undertaken by other actors, typically the executive or the legislature, but certainly not only them. Resistance may be broad or it may be selective and issue specific. And here we have another example from the United States of a federal judge chastising President Donald Trump for unlawfully seeking to end birthright citizenship. The fifth attribute concerns the specific actor or actors whose actions judges are attempting to stop or slow. So one example is a South African Constitutional Court ruling that Parliament had failed over considerable time to hold President Jacob Zuma accountable for corruption. And then the sixth and last attribute concerns the issues or topics of contention. They might be issues concerning public policy or the political regime or many other things. And here we have a cartoon depicting the conflict between Franklin Delano Roosevelt, FDR, and the US Supreme Court over the New Deal. So far we've been discussing judicial resistance in the abstract. Studying the special case of judicial resistance to democratic backsliding entails also being clear on what democratic backsliding is. Doing so entails on being clear about what democracy is. That is, every study of judicial resistance to democratic backsliding needs to define and then be consistent about what is meant by democracy and backsliding. And we see some troubling tendencies in the literature focused on democratic backsliding that we hope to avoid in our work. Scholars appear to be defining democratic backsliding as the set of concerning phenomena that they see taking place in one or more countries of study. So chipping away at legal institutions or executive aggrandizement. And we see at least two problems with defining democratic backsliding that way. First, not every worrisome dynamic that we see going on in a country can be understood as democratic backsliding. What counts or qualifies as democratic backsliding needs to be disciplined by one's definition of democracy and one's definition of backsliding. So for instance, by many definitions of backsliding, many definitions of democracy, much of what scholars seem to be considering as democratic backsliding is actually a weakening of the rule of law. We've already entered into that territory a little bit this morning and how separable those things are. And second, defining democratic backsliding based on what we are observing sort of limits our conceptualization and puts blinders on our studies. Defining democratic backsliding more broadly as a weakening in the quality and stability of democracy, whatever form that takes, allows us to more broadly understand it and all the actors who may advance it. So we hope to avoid those pitfalls in our treatment of judicial resistance to democratic backsliding, about which Benja will tell you more.
Thank you, Diane. So now we will present a brief example of judicial resistance, an effective judicial resistance to democratic erosion. And that's an example from Argentina between 2007 and 2015. The president of Argentina, I would say it's a president considered a left-wing populist. And she implemented several measures over time that could have undermined two central pillars of liberal democracy: freedom of expression and judicial independence. So there are several of these measures that the executive and the incumbent party took. I will just focus on a few of them. So in this picture here, you can see President Cristina Kirchner pointing to a bunch of paper that she says that it proves that the owners of the two most important newspapers of Argentina were guilty of committing crimes against humanity during the last military dictatorship, and she used that to try to imprison them. However, the courts pushed back and stopped that. As a consequence of this decision by so many judges to protect, in this case, the owners of these two media organizations, the government implemented a series of measures against the courts, trying to undermine judicial independence. And in particular, just one of them was I would say, comprehensive judicial reform that the executive was trying to implement in 2013 that would have undermined the power of lower level courts, all courts below the Supreme Court, to stop any decision by the executive branch. However, again, judges reacted and resisted effectively that. So why? How was that possible for the Argentinian Supreme Court and the judiciary in Argentina to be effective? I think this is a particularly or a especially important question or interesting because Argentina didn't have until that moment a history of a strong judiciary with a strong capacity to counterattack the executive. On the contrary, it was a history of court packing, judicial submissiveness, judicial deference to the executive. And I think one of the keys to explain this effectiveness is the people that you see in this picture. The Argentinian Supreme Court, that in the middle of the 2000s was composed by a quite unique configuration of justices that I would say had two characteristics that were quite unprecedented in Argentina. First, all of them had a high level of independence in terms of their preferences from the executive branch. And secondly, they not only were independent, they also had a very clear commitment, I would say a normative commitment and attitudes that led them to defend an idea that the judiciary should stand up and should defend the Constitution from abuses of power from the executive branch and from the legislative branch. They saw their roles as the guardians of the Constitutions from possible violations of the executive and the incumbent party. And in order to accomplish that goal, it was key that these justices, and this is very different from Mexico, they were very united. There were no internal factions or divisions regarding this goal, and there was no competing leadership within the court. They all rallied around the Chief Justice, Lorenzetti, on the left of the picture, who was the one who implemented a series of strategies to empower the court, to empower the judiciary, that consisted in creating coalitions or alliances that could support the courts against the executive branch and the legislative branch. And there are two main strategies that they implemented, one inside the judiciary and one outside the judiciary. In what respects to what they did inside the judiciary, the Argentinian Supreme Court, I wish the US Supreme Court, the Argentinian Supreme Court decided to have a unified position within the judiciary against the executive. So they implemented a series of measures that created a common sense of purpose all across the federal judiciary. And one of them, just one of them, is represented in this picture. They implemented a series of judicial conferences where all Argentinian federal judges gathered. There were several over the years. They met, they created like connections and links between each other. They discussed how they could protect themselves from possible attacks from the executive branch, and also they started to share this vision that the Argentinian Supreme Court had regarding what was the main purpose of the courts in that particular context. But outside the judiciary, the Supreme Court and Chief Justice Lorenzetti decided to open the doors of the courts to civil society and to non-judicial actors. And I'm talking here about hundreds of meetings over time with business leaders, with NGOs, with opposition parties, with media organizations, with law schools, with the bar. So the Supreme Court was very active, reaching out to actors besides just judges. And one example of this, for example, is we can see that in 2012, when all the main leaders of the very fragmented and disunified opposition gathered together to defend the Supreme Court from attacks by the executive. Here we see the Chief Justice having a lot of meetings with the most important journalists of Argentina, trying to spread a common message of unity, and that the Argentina Supreme Court was going to protect the Constitution from the executive branch. And finally, this worked, and the Argentinian Supreme Court was able to stop these attacks, not only against the media, but also against the judiciary. So just to conclude, on a cautionary note, like we were asked about the effectiveness of how judges resist. And we think that we should avoid the temptation of saying, oh, there are these tactics that if judges follow, they will always work. Because what judges do, it's very context dependent. What judges do have a reaction, and what works in one context might not work in another context. So we think we should be very careful about assessing the effectiveness of the resistance strategies. I think it's important to have a list of the repertoire, the options and the tactics that have worked all over the world, and trying to understand why some of them work in one context and not another, and what are the contextual conditions that enable some tactics to work in some countries and not in others. And that's it. Yeah, thank you. And thank you.
Thank you, Benjamín and Diana. Julio?
Well, thank you. Thank you very much to the organizers and Notre Dame University for having me here. I will talk about the two large questions that we were given for this panel. How and under what conditions do executives encroach on the judiciary and the legal system? And then how can courts resist or help resisting democratic backsliding? So on the first question, conditions under which executives encroach on the judiciary, the scholarly literature mentions two key factors that were mentioned at the beginning in the conference at the beginning by Scott and Tom. Two factors that facilitate efforts at controlling the judiciary. The balance of power between executive and legislative, and let's call it the balance of popular support for executive and the judiciary. So in these two aspects, so we used to have fairly simplistic views, I would say, on each factor, or rather we sort of knew how they worked under normal democratic times. But what has happened in countries that are undergoing processes of democratic erosion forces us to think more carefully about how these factors operate in times of democratic stress. So in the presence, let's say, of an anti-pluralist or populist leader, I would say that the judiciary faces or enters into a high-risk zone if two conditions are met. First, there is a unified government, same party of the president controls majority of the legislature, and the condition, the judiciary does not enjoy popular support. The nuances and differences across cases are interesting, just for what Benjamín and Diana have said. Take the first factor, the balance of power between executive and legislative. One of the key elements for success of controlling the court is the relative power between the president's party and the legislature. In El Salvador, I think we have the starkest case, probably. Right after President Bukele won the majority in the midterm, the supermajorities in the midterm, that very same day, he went and take over the Supreme Court and the Attorney General's office. In Mexico and Hungary, something similar happened in these two countries. When the legislative power was not in the hands of the president's party, everything were kind of working normally. However, when the legislative power was nullified by the president's control of the legislative, attempts at controlling the courts were successful. In both cases, Hungary and Mexico, after the party won majorities in the legislative, they manufactured supermajorities so that they actually control changes to the constitution. Brazil, that was mentioned before, is an interesting opposite case, as President Bolsonaro never controlled majorities in the legislative, and he tried but couldn't control the Supreme Federal Tribunal. Actually, the Supreme Federal Tribunal resisted and nullified some of Bolsonaro's policies. And Argentina, I think it's interesting because Cristina Kirchner had majorities in Congress, tried to control the judiciary, but then Peronism is kind of this weird, large coalition that doesn't always command, I mean, which the president doesn't always command complete control. The US here is interesting to think about because what is happening now between the president and the Republican Party. But I would say the more complex factor is the second one, the level of trust in the judiciary or the approval rate, or rather we should say popular support of the judiciary. To actually defend the judiciary in processes of backsliding, what is required, I think, is not diffuse support as David Easton used to say, but rather actual popular mobilization. Do people take the streets when there are open and aggressive attacks on judicial independence? Does the political opposition contribute and strengthen this mobilization, or rather oppose it or obstruct it? What do lawyers, judges, law students, and NGOs do? In my opinion, Israel is perhaps the most impressive recent example of popular support for democracy. The attack on October the 7th changed things, but before that, and actually after that still, we have been witnessing successful popular mobilization in support of the judiciary. This factor, popular support, has been lacking in Mexico and in Salvador, probably also, of course, Hungary, but was present in Poland. In Poland, as Diana said, we witnessed mobilization on behalf of the judiciary, but not only by Polish judges and Polish civil society, but also European judges in the March of the Thousand Robes. Now, why do we see that kind of coordinated and massive mobilization in some places, but not others? If I have time, I will talk more about this in the case of Mexico. But first, I want to talk about how can courts and judicial operators contain the process of democratic backsliding. And here, my answer is, we shouldn't put our hopes in the courts. There is this famous quote by Judge Learned Hand here in the US. I will read it. A society so riven that the spirit of moderation is gone, no court can save. A society where that spirit flourishes, no court needs save. In a society which evades its responsibility by thrusting upon the courts the nurturing of that spirit will perish. So it's really, I mean, judges can do something, but they will not be the saviors of democracy. And a recent book, the title is, Can Judges Be Bulwarks of Democracy? I think the answer is no. They can help, but they cannot be the last instance on which we should put our hopes. Of course, courts have to pick battles. They have to do something. They have to resist, but they have to pick battles. They must prevent, I would say, attacks and the loss of authority, of the authority of their institution, the distinct power that judiciary has in a political democracy. Big fights, I would say, are not good for courts. And this is, I am echoing some of Benjamin's work. However, and this is important, governments in democratic backsliding places oftentimes put courts in the spot with openly unconstitutional laws or decrees. This is really hard for courts. It has happened in Mexico with the military reform and actually with the judicial reform that is taking place now. I think it is also taking place here in the US, and it has happened in other countries. So what do courts do if there is like a clearly unconstitutional, say, presidential decree? If they do nothing, or worse, if they decide in favor of the government, I mean, game over. If they do nothing, or decide in favor of the government, they kind of commit what I would say it's an institutional suicide, essentially finishing, limiting, eating up the authority, the distinct role that they place in a constitutional democracy. They abandoned their institutional role. In Venezuela, the then Chief Justice of the Supreme Court, after Chavez passed this law, essentially giving all the powers to the Constitutional Assembly, the Supreme Court had to rule on that. The majority of the court gave a win to President Chavez, and the Chief Justice of the court said the Supreme Court committed suicide to avoid being murdered. At the end, it's the same thing. I mean, the court was dead and Chavez just went on. However, in those kinds of situations, if courts do play their role and nullify the unconstitutional decree, and I'm talking about openly, clearly, not polemic unconstitutional decrees or laws, then they pit themselves against the leader in a head-to-head fight. So I think it's better to avoid these big cases. Simply not decide them if possible, to wait for better times. Of course, there is also a risk there. Of course, when it is not a war, but a backsliding process, it may be too late when the court takes these cases. If courts solve this type of, let's call them big cases, based on the experience of Mexico, I would say, go for procedural reasons. I mean, just decide the big cases in a small, detail-oriented procedural basis, like Colombia's Constitutional Court in the case of Álvaro Uribe. And I'm finishing. So courts, to finish, I would say are better if you allow the analogy, in kind of guerrilla tactics. So just add roadblocks, enforcing strict legality, delay, complicate the advance of the anti-democratic forces, especially because those forces use law to advance. I mean, this is one of the characteristics of the processes that we are witnessing. They are legalistic authoritarians. And then after that, let's hope for better conditions or the weakening of the regime, and more particularly like a social response. Thank you.
Thank you, Julio. One of the things we've heard already today is that one of the reasons why what sort of public law scholars have called autocratic legalism or this kind of executive aggrandizement process, one of the reasons why it's so hard to resist is that we often don't know where the lines are. We don't know. And of course, right, once the executive starts shooting lawyers and judges, then we know the line has been crossed. But many times we're sort of somewhere between there and what's normal in a democracy. And in fact, there have been many, many instances of judicial reforms that are democracy enhancing, right? So I think the 2005 reform of the Constitutional Court in Chile, which sort of eliminated the role of the military in appointing justices and brought the court much closer to democratic politics, was an instance of democratizing the judiciary, bringing it closer to the country's politics in a positive way, in a good way. That's exactly how Cristina Kirchner defended her project. It was democratizing the judiciary. It's exactly what Bibi Netanyahu says he's doing in Israel, right? And I think Ur this morning said, you know, the 2010 reforms in Turkey were defended in the same way, right? And at that point, right, the Turkish court was capping off maybe 50 years or more of pushing back on democratic demands, right? So how would you, especially the conceptual scholars among us, right? How would you explain to people where that line is, when it's important to stand up to a proposed judicial reform, and when this is just something that's normal in democracies? Democracies make institutional changes all the time.
I can answer this briefly.
Sure.
At least as the lawyer and law professor on the panel, I can tell you the line is the Constitution. When constitutional rights are being imperiled, when constitutional rights are openly flouted by the executive branch, then there is a crucial and critical role for lawyers to ask courts to basically correct the overreaching by the executive branch. That is the duty in what we call judicial review, whether in this country or anywhere else. The challenge is, and this is why I differentiate between courts and lawyers. I said earlier, we need clients. We can't just go to court on our own and say, we think there's a right that's been violated. We need people to actually say, our rights are being violated and we want redress against the courts, or rather against the branch, executive branch. But when people are afraid, especially those who are being abducted, those who are being tortured, those who feel that they have no legal recourse, then that's a serious problem. I agree that courts don't have a lot, the judiciaries in themselves can't do much, but I can say that for courts, first and foremost, because they know they're so politically constrained with not a lot of resources, their main authority is their authority to definitively say what the law is. Anybody on social media can say this is the law, but when courts speak and say this is the law on the subject, that is supposed to be the law for the land. What political actors choose to do with that pronouncement of what the law is exactly what my colleagues are speaking about. So at least insofar as the bar versus the bench, the bar can do a lot, but it also needs clients who want to go to court and access justice through the courts.
Yeah. Well, it's a fantastic question. I think, like, how we can differentiate between judicial reforms that are democracy enhancing and that are attacking democracy, I think I will focus on 3 points. The first one is to look at the executive, like who is the president or the prime minister who is doing this? What are the attitudes? I mean, Juan Lins in the 1970s was very clear that some presidents are more dangerous than others for democracy. Aníbal and Scott in their book in 2013, they also listed why the executive preferences for the type of political regime matter. So I would first say, look at who is the executive and what the executive wants in terms of the preferences. Second, I would say, look at the reform itself with a lot of detail in context. So one characteristic of autocratic legalism or the use of the law to undermine democracy is that many of these measures by themselves might be plausible or they might have been used in other countries to enhance democracy. But when you see them combined, you see, oh, okay, like if you do this judicial reform with this media law, with this law restricting NGOs, all that together, done by this executive, suspicious. And the third point I would say, think about the potential consequences. Not what the government is selling you, but actually what you think, based on what you know about other countries, could happen if all those actions combined are implemented.
I guess maybe I would just shift the terms of the debate a little bit and looking at that move, think about it in rule of law terms, because that's court's job is to back up the rule of law, not to back up democracy, although you may be doing both at the same time. So I guess the questions I would ask is, is it legal and constitutional, this change that is trying to be, that the leaders are trying to put into effect? And how will it affect judicial power and judicial independence, which are different things? But still having democracy in mind, but thinking courts won't be able to bolster democracy or anything else if they are delegitimized, weak, and lack independence.
Mm-hmm.
So I would look at that side of the debate first, which I think is also an easier side of the debate to have when democratic backsliding is in question.
Okay, so I'm not sure that legality and constitutionality help us that much, right? Because I think in Hungary, everything that was done was legal and ended up with democratic decay. And Mexico, which maybe Julio will say something about, right? The current judicial reforms are also being done in a perfectly legal and constitutional way, right? So I don't know if Julio, you have some.
I was going to talk about the Mexican case. It's a hard question. Your question. I wouldn't say that in Mexico things have been done in a perfectly legal. I mean, I would just erase the perfectly, because as in Hungary, I mean, yes, the president, their party, they enjoy massive support, majority support, not super majority support. They kind of manufacture their super majorities in Congress so that they can change the constitution as they like. But they do enjoy popular support. Our president now has 80% of approval. They won 54% of the votes, 67% of the seats. I mean, with this, but they really, they are doing what at least a big chunk of the Mexican population like, and that is a problem. So as you may know, we will have judicial elections in Mexico, popular elections for every single judge in the country, federal and state. In 2 weeks, in 3 weeks, we are voting for half of them. This is absolute. It's a bad reform, badly implemented. It's terrible. It is a hostile takeover of the entire Mexican judiciary. However, the rhetoric is that, we are becoming, and I am quoting our president, Claudia Sheinbaum, Mexico is going to become the most democratic country in the world because now, look, we are the only country that will elect every single judge. It's a democratic trap, I would say. I mean, it is the motivations for the reform were nothing related to, I mean, they say it's to combat corruption, to increase access to justice. Judicial elections will solve none of that and will create a lot more problems. It is a takeover, a political subordination of the judiciary, plain and simple. However, the package is super popular and still so far is being sold well. So what to do, I don't know. In Mexico, we had a judicial strike, judges stroke for like 2 months. There were demonstrations. But that was not enough.
Yeah.
So.
Right. Well, maybe we can open it up. I'll just leave it with one last comment. So I teach a class on law and politics, and we talked about all these topics during the course of the semester. And one of my undergraduate students was really puzzled, and I think it goes to that last thing you said. She said, but is it really true that a district court judge can tell the president what to do? Right? Like, doesn't the president outrank everybody? But I think that's the challenge, right? That the presidents have so much democratic legitimacy, many of them, right? The successful ones, right? And it's hard for people to kind of wrap their heads around how the rule of law is meant to constrain popular will sometimes in a democracy. Right? And I think that tension is something we have to think really carefully about. All right. Well, that concludes the time we have. Let me just finish with maybe another quote from Learned Hand, who said, "Liberty lives in the hearts of men and women. When it dies there, no constitution, no court can save it. When it lives there, it needs no constitution, no court to save it." But I mean, we know that liberty doesn't die in everybody's heart at the same time, right? And there's a lot of division and a lot of dispute and a lot of argument. And that's sort of where lawyers and judges and civil society groups and political parties and elite actors can come in and maybe awaken that spark of liberty that's sleeping in some of these countries. So thank you for a great panel.
Thank you.
And thank you all.
아이고. 왜 탐도 없나?